Should you waive your preliminary hearing in Pennsylvania? This is a very common question that we receive, and there is no easy answer to it. The easy answer is it depends on what's happening with your case. Now, I never advocate or advise simply waiving a hearing just to waive it. You have to be receiving something, or there has to be some tactical reason for the waiver or even doing the hearing. So if you're going to waive the hearing, the prosecution or the district attorney has to be giving you something in return. So in the case of an agreed upon waiver, in most situations, the prosecution should agree to either dismiss or downgrade charges. In addition, there should be some agreement with regards to bail, a negotiated reduction of bail that the judge obviously will have to approve, but again, that is key. Why should you do a preliminary hearing? Well, there's several reasons why. The most important reason is to collect information. You have to understand that a preliminary hearing isn't a trial, but it's an opportunity for your attorney to cross-examine a key prosecution witness and also obtain a record from it. And that record, that transcript, can be used later to set up possible pretrial motions, like a pretrial motion to suppress, which is very important, especially if you're charged with an illegal gun or firearm. It's also important because that transcript allows your attorney to set up possible arguments at trial, especially if the same witness testifies inconsistently at trial from the preliminary hearing. So that's one reason. The second reason is, if the prosecution didn't agree to dismiss or downgrade charges, your attorney, through argument and through cross-examination, can attempt to ask the court to dismiss or downgrade charges because the prosecution has failed to establish what's called a prima facie case for that charge. Now remember, the evidentiary standard of the preliminary hearing is much different than a trial. At a criminal trial, the standard is guilt beyond a reasonable doubt, where at a preliminary hearing, it's prima facie burden of proof, more probable than not that a crime occurred and that you committed that crime. Finally, your attorney needs to use the preliminary hearing to learn about your case, in the sense that you want to test the strength of the prosecution's case. So that's the reason for having the hearing. Why not to have the hearing? Well, in a lot of situations, when your attorney knows that your case isn't going to go to trial for whatever reason, you might want to waive the hearing. Now, in this situation, normally it's where you would qualify for a pretrial diversion program. Now, it's important to understand that you should never assume that you qualify for a program. But in a lot of situations, waiving that preliminary hearing is a condition for a pretrial diversion program, which in many cases is a good result for a case. So for more information on preliminary hearings and criminal defense tactics just in general, I encourage you to look up my website, read what's available there, our blogs, our books, our videos. These are great resources for you. I can't stress them enough. No other law firm in Philadelphia or even in Pennsylvania offers what we offer on our site for free. It's there. We want you to learn about our law firm. In addition, I encourage you to do your research. Look at our reviews online. I'm sure that you'll be happy from what you see online about our law firm. I want to meet you. I want to discuss your case with you. But before you do that, I want you to know me and my law firm. So look forward to seeing you and wish you the best with the case.